Ms. Petti?
Thank you, Your Honor. I'm Russell Petti, and I'm representing the appellants and plaintiffs. With me on this case is Mr. Sam Sharonik. May it please the court and counsel. The ICCTA preempts state laws that have the effect of managing and governing rail transportation while not preempting state laws that have a more remote or incidental impact on state regulation. So, and that's the established test. I mean, the on-bank court in Franks and East Coast Railroad and, you know, numerous other circuit courts. Every circuit court to look at the issue has focused upon and accepted that test. And so the issue here, of course, is whether plaintiffs' claims regulate in some way, shape, or form rail transportation.
Isn't the test it's reasonably said to have the effect of managing or governing rail transportation? Have I quoted it correctly?
You've quoted it precisely, Your Honor. Thank you. So can these claims that we've brought reasonably be said to manage or govern rail transportation? I submit, Your Honors, that they do not. We're not asking the railroads to change the manner in which they operate their trains. We're not saying, well, you know, you can't operate trains during certain hours of the day, or we're not suggesting that they have to, you know, shorten the length of the trains, or, you know, relocate their track, or you know, change the prices that they charge for people to ship on their.
You are saying, in effect, they shouldn't have parked them on the bridges, right?
Well, no, Your Honor. I mean, we're not. I mean, we're seeking money damages.
Of course, any tort claim, that's the relief. But there are lots and lots of these preemption cases where tort claims have been found preempted under that very test, right?
No, Your Honor. I mean, there are really no cases that I could think of that are pure tort claims under the ICCTA that involve just money damages. I mean, in virtually all cases that I'm familiar with, and I think I'm pretty much familiar with all of them at this point, there is some attempt to get the railroad to do something to its track, to increase the size of the culverts, or to not drive during certain hours of the day, or to quit, sending up noxious smoke fumes or something along those lines. I'm unfamiliar with, certainly on the circuit court level, with a single decision that is, that says that a claim for money damages, pure money damages with no injunctive relief, is preempted by the ICCTA. I think there's some dicta in one of the district court opinions that suggests something like that, but the federal trial court decision. I don't really think that's very authoritative, and I certainly don't think it's persuasive, and it's certainly not anything that's been accepted by a court of appeal.
What did the railroad do wrong, or what should they have done differently?
Well, Your Honor, we think that the railroad's negligence, although we've got claims other than negligence, really sort of fits into two categories. Number one, when they realized this flood was coming, in an attempt to protect their track, their bridges, they parked heavily laden rail cars that ran along the length of the tracks. Now, these are low bridges that are close to the water, and so at some point the water rose over the top of the tracks, and these heavily laden rail cars acted as a dam, effectively, that instead of allowing the water just to flow down the Cedar River, dammed up the water and diverted it into downtown Cedar Rapids. That's one of our claim. And the other claim is that at some point two of these bridges collapsed, and when they did, and we submit, Your Honor, they did because they were insufficiently inspected and maintained. I believe they're over 100 years old.
I'm just having a hard time seeing how your theory does not address how the railroad operated its trains. I mean, it goes directly to their use of their trains on their tracks and bridges. Why isn't that preempted?
Well, first off, Your Honor, I mean, there's two answers to that. I mean, those rocks that were in the rail cars, those weren't being transported. I mean, no one was paying them to move the rocks from point A to point B. That was something that was being used for a non-transportation purpose, i.e. protecting their track. But at that point, Your Honor,
isn't protecting their track the whole idea to keep all the other freight that they're paid to transport, to keep that rail line open?
Well, that gets into really the second issue, which is, at some point you have to look to the burden, is it a substantial burden that we're talking about, to the extent you do have some impact on rail transportation. And the fact of the matter is telling the railroads, look, you can't park your rail cars on tracks in advance of a flood when the bridge is really low. I mean, that's not much of a burden, because at the end of the day, Your Honors, floods don't happen that often. It's not, they get up and say, well, it'll impact the manner in which we operate in the 48 states, and it just won't. I mean, it's a historical event. Probably they wouldn't do it that way again anyway, if the flood happened. As a matter of fact,
that's kind of looking at it after the fact. At the time, I mean, their view, it turned out wrong, was that we would preserve these lines from collapsing by putting these rail cars on the track. I mean, that seems to me to say they can't act to preserve their own rail lines, that if they were taken out would completely eliminate their ability to transport across the Cedar River. That seems to me that is a pretty significant burden.
Well, Your Honor, number one, the intent. I mean, we have to look at this going forward, because the question is if assuming that we get this case turned around and back in front of the trial court, and they issue some sort of judgment, is that judgment going to have an impact on rail transportation? That's the issue. So I mean, looking at what happened back in the day, I don't believe that's the issue before this court. The issue before this court is whatever ruling, if the court rules in my favor, is that going to impermissibly burden rail transportation? And I submit that, being as all we're asking for is a money judgment, that the answer is no. But
you mentioned that earlier. You said, give me a federal appellate case that it was just a pure tort claim and it was preempted. What about Ezel, decided by the Fifth Circuit earlier this year? I mean, the claim was, it was a pure negligence claim. It was personal injury, which seems to me to take it further away potentially from the ICCTA than this claim. And the issue was simply the amount of time the train blocked a crossing. They weren't asking for an injunction. It was purely damages, right?
Is that the Elam case, Your Honor?
Ezel, decided by the Fifth Circuit, Judge Higginson, earlier this year.
Okay, Your Honor, I'm afraid that's one that I'm just not familiar with, and I'm happy to take a look at it and write a supplemental thing. But I mean, I think that the Elam case really talks about sort of the same, situation where you have a train parked across a crossing, and the car comes and runs into the train while it's sitting there at the crossing. And I think it's an instructive case, because there were two claims that the plaintiff made. And one of them was that sitting there at the crossing that long had violated the state's anti-blocking statute, and the other one was that a simple failure to warn, put up lights, give some sort of indication that there's a train sitting there. The Elam court held that the anti-blocking claim was preempted, as frankly all anti-blocking claims are held to be preempted, because it's a direct attempt by the state to govern how the railroad is going to run its trains on its tracks and how long it could, the trains could be maintained. But it held that there were obviously issues of fact with respect to the simple negligence claim, and that the simple negligence claim was not subject to facial preemption. And I submit that neither. I mean, the argument was never, suggested that there's a preemption involved because, the railroad might at some point have to pay some money. And but getting back to the point of, well, maybe the railroads are going to have to do something a little differently in the past. I mean, I think that was sort of addressed by the Supreme Court in the Dow Chemical case, which didn't deal with the ICCTA. It dealt with pesticide labeling, and the plaintiffs, the defendants in that case, believed that they had complied with federal labeling law. They were sued under state labeling law, and the argument that was made to the Supreme Court after the plaintiffs prevailed below is that well, we're going to have to relabel our labels, which already comply with state law. And the response of the Supreme Court was, well, maybe you do and maybe you don't, but you injured these people, and you have to pay a judgment in order to compensate them for their injury. And I mean, if you have to relabel, if you want to relabel your packages, that's fine. But the fact that a money judgment causes you to act in a particular fashion is not necessarily something that figures into our preemption analysis. And frankly, Your Honor, I mean, judgments should cause people to act in certain ways. I mean, judgments, I mean, perhaps the railroad should do a better job of inspecting their low-lying railroad bridges, and perhaps before they park heavily laden railroad cars on a low-level bridge where they're expecting the water to overtop the bridge, they should think about the ramifications to nearby property owners. And I submit that it's not good public policy to immunize, which is effectively what's going on here, to immunize the railroads from the impact of that decision.
Mr. Petti, what if the railroad was hauling the rocks in these cars from point A to point B, and they decided on June 10th of whatever year, 2008, that this flooding occurred, that they would stop the trains in this area where the bridges were to put the additional weight on the bridges in hopes that they wouldn't be affected by the flood. And so they stopped the transportation for a day before they were going to go on to point B. Would that be immune?
Well, Your Honor, it would probably be a better case, but I submit that just as in Elam, I mean, in Elam the train was in the course of transportation. I mean, it was stopped for a while, but I mean, it was moving from point A to point B. The issue is not whether there's rail transportation involved. The issue is whether we are, by our claims, attempting to regulate rail transportation. And I submit that to the extent, and there'd be a better argument that we were attempting to regulate rail transportation in that particular case, but again, I get back down to the minimal burden involved.
As I understand Elam, I mean, there were two claims. One was preempted and one wasn't, and I find the case kind of instructive. So the one that was preempted was the negligence per se claim based on the anti-blocking statute. In other words, the argument that you can't have the trains there because that's dangerous, that's negligent. That claim's preempted. The failure to warn claim was not. So there's the argument is your trains can go where they want, you just need to sound the horn better. That seems to me, if you draw those lines, it seems to me we're on the first side, on the preempted side, if we apply Elam here, aren't we? Or am I missing it?
Your Honor, I disagree, because I mean, anti-blocking statutes are held to be preempted. I mean, they're they really fit within the category of the facial preemption, which is something which is preempted on its face because it's obviously an attempt by a state government. Let me just back. I mean, the anti-blocking statutes are statutes that say you can't block a road crossing for more than, 30 minutes or an hour or however long it happens to be. And basically you are telling the railroad, you're issuing a law that mandates the manner in which they drive their trains, how long their train could be, and telling the railroad how it's allowed to drive its trains is something which is facially preempted by the ICCTA, and everybody seems to agree with that. Now, we're not attempting to tell, with our claim, the railroad how to drive its trains, where to drive them, how long the train should be. We're just seeking money damages.
Sam, but when you're I'm going to stop.
At any rate, I think I'm out of time, Your Honors. If there's no further questions, then I'll wait for my next turnaround. Thank you, Your Honors.
Thank you as well, Mr. Petti. Ms. Loughran.
May it please the court. My name is Alice Loughran. I represent Union Pacific. As the court is well aware, the issue in the case is whether these state law remedies alleged by plaintiffs in this complaint are preempted by the second sentence in section 49 U.S.C. 10501B. I recognize that the parties have used a lot of terms in the briefs. There's conflict preemption, ordinary preemption, complete preemption. What the focus and what's really necessary here is express preemption, because that was the basis of the district court's ruling. And with express preemption, the first place we always start is the statute, the language of the statute. And here the language of the statute states, and this is in the second sentence, the preemption provision, that the remedies with respect to rail transportation.
Oh, isn't it with respect to the regulation of railroads? That the language? With respect to...
With respect to the regulation, yes.
Regulation. And isn't there a difference between a regulatory framework and a tort framework? I mean, that's common in the law. We recently, a couple of years ago, decided an environmental case, and there's a passage in it that talks about regulation is for the public benefit. It's broadly applicable rules, and nuisance claims that this happened to involve is a specific retrospective remedy that serves different functions. The ITTCA was the successor of the ICC, the height of regulatory agency, gateway eliminations and certificates of convenience and all this happy stuff. So it strikes me there's a considerable difference between regulatory framework and a tort framework. With respect to regulation, the State Transportation Board can't promulgate rules and regulations on railroads. But isn't this a different kettle of fish?
Well, Your Honor, I mean, it's a basic principle that we learned from law school that tort claims have two purposes. First, to compensate, and second, to shape behavior. And this U.S. Supreme Court...
Well, but if they wanted to preempt torts, they would have done it specifically.
Well,
The Congress isn't shy about expressly eliminating tort claims. It's done so hundreds of times. Here they use the term with respect to regulation of railroads.
Correct, Your Honor. Regulation of railroads, with respect to regulation of railroads, and preempt state laws. They did not distinguish between the source of the state laws. What the courts are looking at is not the source, what type of state law it is, what would the intent of the drafters is.
I mean, at the end, it says preempt the remedies provided under federal or state law. It doesn't say limited to state positive law. It could be state common law.
Correct, and as the court is well aware, Congress, sorry, go ahead.
Well, let me ask you this. We've all been around long enough to know that when immunity statutes are passed, it's a battle royale, and the lobbyists emerge, and you have a big fist fight. What does the legislative history show with respect to the passage of this ITTCA? Was there a big brouhaha over this immunity provision, or did it just kind of slide under the radar?
Well, let me answer that. First of all, we think the statutory language is where you start, but the legislative history talks about the concern of patchwork. And as you...
Sure, patchwork regulation, absolutely right. But it doesn't talk about, I don't think, and I'm giving you the opportunity to correct me, I don't think there's a word in the statutory history that relates to preempting state tort claims. Correct me if I'm wrong, because I'm interested.
Well, I don't think, if you look at the case law, at the legislative history, and I didn't look at it yesterday, but the concern is about the patchwork of regulations.
Patchwork of regulation.
They don't distinguish between the type of claims. And again, if you look at the case law, the cases under this ICTA provision, there's, I think we cited over 30 cases that are laws of general applicability. And those were courts that really just squarely address the issue. But there's a lot more out there. So the plaintiffs are really have a wall of precedent that they're walking up against. And what the concern of the courts, if you look at, when you go through the cases that are cited on page, it's footnote 20, we have, I think, over 30 cases in the corresponding text talking about laws of general applicability, that it doesn't turn on the generalities of the state law, but it turns on the effect that it'll have on interstate
I think, as I read the case law, there's a secondary test, which is to what extent does it burden the rail transportation, I believe. But that's generally a factual test, I think.
Yeah, I'm glad that you brought that up, because we are in disagreement about that with the plaintiffs, that it's not a second independent test. That once the court finds that it manages or governs rail transportation, that is express preemption, and the analysis ends there. So on the Franks decision at 410, the court says laws that have the effect of managing or governing rail transportation will be expressly preempted, and the analysis ends. And so there's no sort of factual analysis, because Congress has decided, it has made the determination on the burden.
Just about every tort claim, every state tort claim against a railroad related to its operations is preempted by this statute talking about regulation of railroads?
Well, and I'm glad that you brought that up as well, because that goes to the plaintiff's argument that we're asserting immunity. We're not trying to claim immunity, because I think if you look at the cases, there are 3 different types of cases.
Give me an example of a negligence claim that would not regulate railroads.
Okay, well, there's the Emerson case, which is cited by the plaintiffs, and that is a case where it was rail ties, and they weren't being used anymore, and they were thrown out. And I guess the accumulation of those rail ties had caused some flooding. And the court said that was not managing, because it wasn't furthering rail transportation. The rail ties had already been used. Another example is a case that's cited in our brief, where CSX had their yard, and they had a wall that prevented noise from going to outside to the neighboring property. And that wall came down. And when it came down, CSX did not put it back up. And it ended up that caused or diverted water. And the court said in that case, that wall was not there for a rail purpose.
Well, suppose a railroad had a dangerous curve and had a narrow gauge track of some kind, and it was an unstable situation, and there was an unfortunate accident, and a lot of people injured and so forth.
Right.
Of course, a lot of them reconsider the gauge of the rail and so forth. So that would be preempted?
No, and I'm glad, that's a very good example. That's another good example of where the railroads would not be immune. Because that's a situation, as the court may be well aware, there's heavy regulations. Despite Congress's deregulation of the industry, the railroad industry is still the most regulated industry in the country today. So the Code of Federal Regulations has hundreds of pages dealing with the primary
But
conduct.
absent that regulation, you say would a state tort claim be preempted?
So the way it works, and it's sort of pointed out in the cases that the plaintiffs cite, that there would be a negligence claim, but there would be no state duty imposed on the railroad, that it would be a federal duty. And that's really what the dispute is
This would
about.
be where the Federal Rail Safety Act comes in. So if there's an accident, somebody's hurt, you could sue for violation of whatever federal standards, like in that Amtrak accident that happened where the person was taking the curve too fast or whatever. But that's a separate, your argument is that's separate from ICCTA.
That's separate from ICTA, and the way the courts, as I understand it, even the cases that the plaintiff cites, which is Smith versus CSX, as a district court in Ohio, where the court said it's preempted by ICTA, yes, but here they're alleging the violation of a federal duty, so you cannot use ICTA to get dismissal of this case.
What was the law prior to the passage of ICTA with respect to state tort claims against railroads?
Well, as the court is well aware, I mean, the railroads are an interstate operation, and so there's a lot of precedent on interstate operations. As to bridges, we think that there is...
Just generally, let me phrase it differently, did this legislative provision with respect to regulation of railroads that you're citing, did that change prior law?
The language in ICTA, I think it preempted.
The specific preemption language, yes.
I think that it, yes, I think that Congress intended to preempt more than probably what had been preempted in prior precedent. But in prior precedent under the Interstate Commerce Clause, there had been a lot of precedent saying that you can't regulate the railroads because state duties on an interstate operation is not manageable.
Aren't there cases under the, before ICTA, I'm sorry, I mispronounced it.
No, you're fine.
That allow state tort claims to proceed against railroads in a number of contexts?
Before ICTA? There may be.
I just think, I mean, I'm struggling. You're really putting a lot of weight on the preemption language, and as well you should. I mean, I understand it's a preemption case, but what you're really saying is that Congress used a phrase and language that talks about with respect to regulation of railroad that really has sweeping implications for application of state tort law. It seems to me it's just kind of if that's what Congress intended, wouldn't they have put an exclamation point on it or spelled it out better?
Well, it is the language, and certainly there's a lot of a precedent that's already accumulated. I mean, the 11th Circuit has said that there's no exception for damages remedy, and that was a nuisance case. The 8th Circuit dealt with a negligence case that they found preempted in the negligence context. With the court's permission, I'm actually intruding on their time, so if possible, thank you.
Thank you as well, Ms. Loughran. Mr. Thornton, the bailiff put 5 minutes on the clock, please.
I'm sorry, Your Honor?
Please proceed.
Thank you. I think to answer the court's question, your question in particular, Justice, regulation equals managing or governing rail transportation. And when a state tort claim manages or governs rail transportation, it is preempted. And the situation here is that there's no question about that they're going to be managing or governing rail transportation because an award of the scope that the plaintiffs want in this case certainly will cause the bridges to be redesigned.
Do we know what the scope is of what the plaintiffs seek in this case?
Well, they're seeking $6 billion in what they've talked about. Now
Is that in the pleadings?
Yes, it is.
Is it in the record?
It is in the pleadings. And it's in their briefs.
I think it's in the briefs, but not the petition is where I found it, because I was wondering where you.
Well, you're right. It's definitely in the briefs. Because of that situation, there's no question that the railroads would do things differently. And they would end up doing things differently in Iowa than they would do in other states that wouldn't allow that sort of action. And that's the problem. That's the situation that Ms. Loughran was talking about.
Any state tort that might deter or affect railroad operations is preempted in your view?
Certainly, the South Dakota Railroad case, the South Dakota Railroad Authority case, found that the significant damages would have the impact on rail routes and South Dakota shippers. Judge Kornman found that in South Dakota, whereas in North Dakota, in the Minot cases that I handled, where there was a derailment that released anhydrous ammonia throughout the city of Minot, the cases were not necessarily preempted. So the issue is, would it affect rail transportation? And there's no question that a damages award of this amount would affect rail transportation.
Well, Counsel, you suggest that a large damage award would cause railroads to do massive reorganization, redesign bridges and the like. Isn't an alternative consequence maybe that they just wouldn't do what was done in this case? They'd stop putting heavy cars loaded with rocks on a bridge in the event of a flood. I mean, would that be such a massive regulation of rail transportation, just stopping that?
Railroads what is the difference between an anti-blocking statute and parking loaded cars laden with rocks on a bridge?
Statute is a regulation. This is a tort claim. It's fact-specific and.
It is a tort claim that has an effect on rail transportation, that manages and governs rail transportation insofar as the situation is presented here. And
Indirectly, I think that's
I'm
perhaps, indirectly, that may be right. But doesn't the case law talk about indirect impact is not necessarily meaning preemption?
Well, what the case law talks about is remote and incidental impacts on rail transportation doesn't have those effects. But this wouldn't be remote, this wouldn't be incidental, this would be.
Why not? I mean, it's not a direct, I mean, there's a question as to what incidental means, maybe. Does incidental mean caused, or does incidental mean substantial? But the state law claims here are not directly regulating railroads. At least I'm having trouble seeing that. I do understand there may be some indirect impact. But help me with.
Well, the statute, first of all, doesn't use the word direct, and most of the cases don't use the word direct. They use managing and governing as the operative language.
The operative language actually is with respect to regulation of railroads.
Regulation, and the cases have interpreted that to mean managing and governing rail transportation. And when rail transportation is managed and governed, as it would be in this case, there would be no parking of cars, there would be no designing of bridges in a way that would be subject to a monumental flood, a flood that has never been experienced before in the state of Iowa or any place else. And the situation was such that the railroads wanted to prevent their bridges from going down so they could preserve the interstate commerce situation, and that situation was such that the railroads took an action which they thought was necessary, and it turns out in retrospect it was unnecessary, or was imprudent, I guess, in retrospect, but the railroads have to be allowed to take the actions that they take.
Thank you, Counsel.
Thank you.
Mr. Petti.
Thank you, Your Honor. May it please the court. And I agree with Justice Appel.
Don't necessarily. I may have some questions for you.
I'm sure you will, Your Honor. I mean, the point is that, you know, if you're going to essentially immunize the rail industry from large, sort of a large sector of tort law, it seems to me you'd be a little bit more express about it. You'd have something in the legislative history that said that's what you were doing. There'd be some debate about it. There would be some more, you know, I mean, it's a fairly extraordinary thing. I mean, we were thrown out on the, dismissed on the pleadings. I mean, there was no need for the railroads to come forward and present evidence showing that you know, having to pay this judgment and having to, you know, depending as to whether they would act differently in the future, how that would have a substantial impact on rail transportation, or any impact at all.
The suggestion is whether or not this is a action with respect to regulation of railroads, is it has impact, and I'm going to paraphrase, and I'm sorry if I'm not accurate, but a substantial tort judgment would have impact on the manner of management and operation of the railroad. And it is a true fact that, I mean, going back to our law school days, you know, you expect tort judgments to deter. It's one of the reasons for tort claims. And I think they're saying, well, that's the problem. An effective tort claim deters railroads from certain kinds of conduct, and where that conduct relates to transportation, not throwing the ties down the ravine, that should be considered a regulation.
Well, first off, Your Honor, the amount of the judgment is entirely hypothetical. There's nothing in the pleading as to the amount that's being sought. The amount of the judgment is dependent upon class certification, something which hasn't happened yet. But you know, I submit that it doesn't make any sense to suggest that the size of the judgment has any impact on whether something is preempted. I mean, you know,
well, it affects. I mean, wow! It affects behavior. Surely it does.
Well, you know-
And it may be direct or indirect. I don't want to get into the causation theology here necessarily, but it is, I think, a fairly well-established principle that money damages and tort certainly have the potential of affecting behavior. And in this case, should you be successful, it may affect the behavior of railroads with respect to maintenance and repair of bridges, and with respect to loading rocks and cars and putting them on trestles at time of flood.
The Duncan case in the Ninth Circuit, which was dealing with airline deregulation, and you know, fairly similar in scope and purpose to the ICCTA. And in that case, there was a state law that said you couldn't smoke in the workplace, and the airline, Northwest Airline, had a flight to Asia where they allowed smoking, and there was a suit on behalf of the you know, the people who had to, you know, the stewards and such in order to present that. And the Northwest made that exact same argument. Well, we'd have to do things differently if we had to pay judgment to our employees who, you know, because they're in this smoky environment.
Well, do you agree with the proposition that there can never be any type of economic regulation that would be sufficient to allow this?
No, Your Honor, because there are two significant caveats to the, you know, for example, just in the Washington County case, they're talking about a state statute, 372F.2, that deals expressly with, you know, bridge repair and railroad bridge repair. So I mean, it's a direct attempt by a state to regulate.
I guess I was
There was a
referring to.
highway involved in that case, right? It was a highway rail bridge. It was a highway going over and under a railroad, right?
But the statute itself doesn't make any mention of highways. The statute itself talks about rail bridges, but, you know, I mean, you've got.
That entered into the decision a lot.
That had some impact on the decision, but I submit that the more significant focus of that particular decision was that they said, look, I mean, this statute predates any federal regulation of railroads whatsoever. The state government has been involved in the rail safety business and the bridge safety business since well before the feds got involved, and we're going to take that into account in determining this. And my time is up, but I'm happy to answer any more questions that the court may have, or if I've answered you.
The $2 for Justice Zager, because I think I blocked his question.
Well, I will have one more question. Again, going back to the case that counsel made reference to, where the court did in fact take into consideration the economic impact that this would have, and then extrapolated that out to say that it does have the effect of having an economic regulation over the railroads, which I think has been argued in both of the, you know, the briefs that have been submitted. And I guess I just wanted your response to that. Is there never a situation where you can look at the economic effects and possible regulation of the railroads and their effect on their behavior?
If you're talking about the size of the judgment rather than the existence of the judgment, Your Honor, I really think that just doesn't make any sense. It just doesn't figure into the preemption analysis. I mean, if I can give you an example, the railroad employee is, you know, course and scope of business, driving a truck on railroad business, and falls asleep at the wheel, and, you know, runs into a crowded pedestrian mall and, you know, injures, you know, dozens of people. I mean, that would be a big judgment, maybe a big enough judgment to have an impact on rail operations. What if he just hit one person? That would be a smaller judgment. And, you know, I mean, you just can't, you know, how many people you injure just can't be the question to determine the scope of federal preemption. I mean, the issue is what Congress intended. If I've answered your question, Your Honor, and I'd be happy to take any further questions or submit, then thank the court for its time.
Mr. Petti, thank you as well.
Thank you, Your Honors.
The case of Griffioen and others versus Cedar Rapids, Iowa City Railroad and others is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.